All right. Thanks again for joining us. I got our presentation up, so we'll go ahead and get started. Again, my name is Jordan Walker. I'm with Seaver Walker Padgett Law Firm. I am a licensed attorney in the state of Texas to practice law. I am an eminent domain attorney. Our firm at Seaver Walker Padgett are eminent domain only attorneys, and we only represent landowners who are affected by eminent domain. So with that being said, we will go ahead and get started. A real one, actually. Yeah. 1 second. Okay, sorry about that. Okay, we'll go ahead and get started. Real quick, what is eminent domain? Eminent domain is the forced acquisition of private land for a public use. Most traditionally, eminent domain is exercised by the Texas Department of Transportation or states, counties, or the state of Texas, counties, municipalities, cities, any government entities, the more traditional condemnor, as they're referred to as entities that can acquire land for a public use. Public use can be defined and interpreted many ways, but for the purposes of this project, the SH31 project, a road projects are presumed public uses, meaning unlike a utility or maybe the acquisition of land to set to redevelopment uses, there's no real debate as to the public nature of these acquisitions because they're being set to a public use, that being a road. So the long and short of eminent domain is that ultimately they can take land if they are condemned or a state, in this case, the Texas Department of Transportation. They can basically take your land whether you like it or not. Meaning you can't just say, no, I don't want to sell you my land. Eventually, they will get it, if necessary, utilizing the courts. And utilizing the courts to get private land and put it to a public use is effectively eminent domain. So while they do have the power to take land, they also must pay what is called just compensation for that land. Just compensation, in other words, money. And it isn't necessarily any amount of money, it is just compensation. So in other words, it needs to be inclusive of every possible impact that the acquisition may have on the property. In these scenarios, again, the condemnor, the Texas Department of Transportation, has inherent eminent domain authority. As a consequence, they are presumed to be able to take the land, assuming they follow the law in pre-suit negotiations. That's all to say that it is very difficult to challenge these types of takings. So if the state comes in and they want your land, it is very difficult to stop them from doing so. It isn't impossible, and we've done it before, but it is not an easy task in these scenarios. There is a lot of case law that supports the right of the Texas Department of Transportation to take land for a road project. So that's what eminent domain is. Let's talk about the project a little bit. The SH31 project. We're not going to talk a ton about it because you probably already know about it if you did receive one of our letters. The Tyler District of TxDOT is proposing to construct basically a widening of SH31 from Kilgore to Tyler. And this would be in Smith and Gregg counties. And this project is going to involve obviously a lot of different components to it. But I think the long and short of it and the takeaway is that they are widening this road, and as a consequence, they need quite a bit of property, private land, in order to do that. And if you received one of our letters about this webinar, it's because we believe that your property is going to be affected by this project. And affected means that, in our view, and this is from publicly available information that TxDOT has released, that in our view that they're going to come to you at some point and want to acquire your land, which is why we sent you a mailing. Ultimately, if they want your land, they have to contact you. They have to initiate discussions. We'll talk about what they need to do here in a bit. But if you're not sure if they need your land, the long and short of it is that they will contact you. This is not a scenario, these types of situations, it isn't normally a scenario where they don't make their presence felt. They're going to contact you. They're going to make you an offer. They have to by law. It's a very open and obvious process. So in other words, if you're concerned that maybe you haven't received anything and you don't know what's going on, and you're just going to end up in eminent domain, all of a sudden, that's not how it works. They will make their presence known. And so what happens, what is the eminent domain process in the state of Texas? Well, so there are laws set forth in the Texas Code, which set forth the process that a condemnor, a taker of land, must follow before they initiate their condemnation lawsuit. It isn't, as I discussed earlier, isn't a scenario where they can just show up one day with a lawsuit and sue you and take your land. They need to follow certain requirements. And in fact, they need to follow what's called the Landowner Bill of Rights, the LBOR, as I've identified it on this slide. So the Landowner Bill of Rights is a series of requirements, protections for landowners in this exact scenario that you find yourself in, that being eminent domain. The LBOR is a list of code requirements, statutory provisions that protect landowners from eminent domain overreach in the state of Texas. And as part of that LBOR, the Landowner Bill of Rights, there's certain precautions, requirements put into place that we're going to talk about right now. And these are the pre-suit requirements of the condemnor, or the Texas Department of Transportation. And this is a schedule, the tightest schedule allowable by law. So in other words, there's a certain requirement, for example, when you receive your initial offer from the condemnor, that's day one. And these schedules are the absolute quickest that the Texas Department of Transportation can proceed prior to initiating the condemnation lawsuit. So, for example, let's say you received your offer today, and you received your initial offer, and that's a specific type of offer. It is the initial offer. On day 24, the absolute minimum, meaning the soonest that they can, after that initial offer is issued, and 7 days prior to the final offer, they would issue the landowner a copy of the Landowner Bill of Rights to the landowner. This is all to say that from that this process can move pretty quickly if the Texas Department of Transportation allows it to. It isn't always going to look like that, and honestly, it's probably not going to move this swiftly or this quickly. But this is the legal minimum that's allowed. So I tell landowners to be prepared for it to go quickly, even though it might not, just so you're prepared. So on day one, you've received your initial offer. So the initial offer will be extended to you. It will be in writing, and it'll be issued by the right-of-way agent by the Texas Department of Transportation. And then after that offer is issued on day 24, so approximately 3 weeks later, at the minimum, or this as soon as possible, as soon as this is the soonest you could get it, on day 24, the Landowner Bill of Rights is issued. Again, this is a list of rights that a landowner enjoys in the state of Texas. On day 31, at least 30 days after the initial offer, at the very least 30 days after the initial offer, you get the written final offer. So you get the initial offer on day one. 3 weeks later, you receive the Landowner Bill of Rights. And then a week after that, you'll receive the written offer at minimum, as soon as possible. In that written offer, it has to include an appraisal report, which is equal to or a greater than the report or the offer itself. You will have a copy. You need to provide a copy of a conveyance document, that being a deed or an easement or whatever they need from you. They need to provide a plat map of the acquisition that they want, what they need from you, basically a map of the acquisition. And again, it must be in writing. It must be issued in writing. However, the initial offer, even though it doesn't necessarily need to be issued in writing, as a writing can't talk. It must be a written offer for the final offer. The initial offer doesn't need to be in writing, but generally it is. All of this is generally issued in writing, whether it needs to or not. Our firm will get involved as soon as the initial offer is issued, sometimes sooner. So if you're looking to hire an attorney, if you're interested in hiring our firm to help you out with this acquisition, generally we get involved when the offer is issued, because that is your case. That allows us to evaluate the acquisition, evaluate the offer, determine whether it's a good offer or bad offer, or whether or not the offer adequately protects you from what's happening to the property. So the eminent domain process continued. So it's day 31. You've received the written final offer. What happens then? Well, at minimum, on day 46, so 2 weeks after the written offer is issued, the Texas Department of Transportation is allowed to file their lawsuit against you, because they've waited the statutory time period before filing their litigation. So it's possible that from receiving your initial offer to litigation could be as short as 45 days, 46 days, less than 2 months from the initial contact to litigation. So this is all to say that this process can move very quickly again. And if you don't pay enough attention to this, you could end up in litigation before you know it, after you've received the initial offer. So just keep that in mind when you start getting communication from TxDOT, because this process can move quickly. On day 46, litigation is filed. The condemnation complaint is filed. You are in eminent domain at this point. The petition, in other words, the lawsuit is filed. As soon as that petition is filed, a board of commissioners is appointed by the judge that is presiding over your case, over your condemnation complaint. And this board of commissioners, their duty basically is to determine preliminary compensation for your property. And so going back to the timeline, you're in litigation. The Board of Commissioners has been appointed by the judge that's presiding over your case. And about 45 to 60 days after that, or at least 20 days after the commissioners are appointed, and plus an additional 10 days to strike any of those. So in other words, on day 90 to 120, so 3 to 4 months after you receive the written offer and you're in litigation, these are rough timelines, of course, the Board of Commissioners will hold a hearing on preliminary just compensation. So that board that the judge appointed to determine preliminary just compensation will have a hearing over that, determining what that amount is. You can participate as a landowner. The DOT can participate as the taker. Ultimately, they will hear evidence from the parties. They will use their own, of course, their own expertise such that they have it, and they will come up with a preliminary determination on just compensation. The DOT will then deposit that amount with the court, and then they take title to the land. It is at that point that you as a landowner would object to that amount of money if you disagree with it, and that the DOT also has that amount. So let's give an example. Let's say the Texas Department of Transportation offered you $50,000 for your land initially. You couldn't work out a deal. It reached litigation. They filed their lawsuit. The judge has appointed the commissioners. Commissioners hold their hearing. You present evidence, they present evidence. The Board of Commissioners determines that you're entitled to $100,000. But let's say you still don't think that's enough money and that's not appropriate. In that case, you need to file a timely objection to that amount, to that determination by the Board of Commissioners, so the case proceeds to a jury trial on final just compensation. If you don't file an objection to that amount of money, and let's say the DOT doesn't file an objection to that amount of money, the case is over, and that's your compensation in that scenario. If either party objects, then the case continues on for a determination of final just compensation over what you're entitled to. And you do have a jury trial to determine that amount. This is all to say that this is a very compressed and aggressive schedule in Texas. And it's important that when you get the offer, when you get these offers, communications from the state, that you are vigilant in your response. And to that end, this is what we generally advise for folks to do when they receive an offer. Insist that the right-of-way agent communicates via email only. we generally don't advise getting in-person verbal discussions or on the phone discussions with right-of-way agents. It's always good to have everything on the record when you're talking, when you're having these discussions with the DOT. So what we tell folks is, as soon as it sounds like they're going to issue an offer, if they haven't issued in writing, insist that they issue it in writing, and further insist that all communications are in writing. Via email is the easiest way to do it. You can also text, of course. That's as long as there's a writing between the parties that establishes what's being said, then you're doing things the right way. So what I tell people is, as soon as you get the writing, tell them, give me a week, I'll review it. You, the landowner, will review it, and then you'll get back in touch with them. In the interim, you can then take that offer, send it to the attorney that you're potentially going to hire, have that attorney review the document, and then determine a plan for moving forward, determine how your case should proceed, get a strategy. This allows you to do your due diligence, but you're also not putting them off, the DOT, that is. So they're not going to run to the court and file their litigation. You're giving yourself some time, but you're also informing them that this is on your radar and it's something that you're going to respond to in some fashion. What not to do when you get an offer. So that's what you should do. What you shouldn't do. I would not just leap into negotiations or discuss value before talking to an attorney. That's usually how landowners end up in a trap or end up in a situation where they end up getting less than what they're entitled to. It's kind of first nature to jump in if somebody lowballs you and kind of highball them, so to speak, or respond with a much higher offer. But the reality is, with these types of acquisitions, especially when they're partial acquisitions and they only acquire a part of your property, that these are relatively complex valuations of your property, meaning there's a lot of impacts on your property that maybe you might not even realize. And beyond that, you have to recognize what's compensable, because not every component of your case is something you can get compensation for. In other words, if you've owned your land for 100 years and you think that you deserve a premium because your family has held this property for so long, in the state of Texas, that doesn't mean anything. You don't get money for owning the land for some period of time. In other states, you might, but in Texas, you don't. And so it's important to remember, or it's important to know what you're entitled to before you get in these negotiations with right-of-way agents. And to that point, I generally don't advise going out and getting an appraiser unless it's necessary. And in our view, it's not necessary unless you're in litigation. It's very important. Finding an eminent domain appraiser is not easy, and they are not cheap. So if you're going to go that route and get an appraisal, you want to make sure that it's necessary that you do it, and you need that appraisal to get where you want to be from a compensation perspective. But it's also important to hire somebody that knows what they're doing. Not every appraiser can do this, and even if they can do an eminent domain appraisal, they might not be qualified to do so. So it's important to not just jump in and start spending money on an appraisal unless it's absolutely necessary. We already talked about meeting in person. I generally would avoid those with right-of-way agents. But beyond that, the final 2 points I would say is, don't rush into a decision, but also don't ignore it altogether. This is not something that you just want to put aside and out of sight, out of mind, and avoid. You definitely want to address it, but do so in a smart manner that includes some level of strategy and planning for what you want out of this and what you want to accomplish. As far as hiring an attorney, I cannot speak for other law firms. I can say that our firm operates on a contingency. If you're interested in hiring an attorney, or at least interested in hiring our firm, we operate on a contingency fee basis, which means our fee is contingent on how much more we get than what is offered by the Texas Department of Transportation. If you're offered $50,000, or we'll keep it easy with the numbers on the screen. Let's say you're offered $10,000, you hire our firm, and we get you $100,000. In that scenario, we take a third of the case, of the money that we add to the case, and you get the rest. There is no, if you wanted to be my client, for example, you wouldn't need to write me a check or anything. It'd be as simple as signing a contract and us taking over from there. The money comes out at the end, and you don't need to come out of pocket to hire our firm. And with that, I will let you go. That is the end of my presentation. Moving forward, if you have an offer, seek out counsel for sure. If you don't have an offer yet, I'd say start vetting attorneys for who you'll eventually hire. If you have questions, further questions about eminent domain, our firm, or this project, you can call me at 737-252-1936. You can also text me at 470-869-1383. You can also email me at Jordan, Jordan, at swp-legal-.com. And with that, I will leave you. Thank you so much for stopping by today, and let me know if you have any questions.